Hi everybody, welcome. It's a little different than Sardi's, but we have some important business to talk about here. What's that? Well,
Better food.
Better food than Sardi's, okay. Actually, I like the food at Sardi's. I just ate there recently. I was reading Ken Davenport's blog. Everybody know Ken Davenport's blog? What is it, Producer's Perspective? He's an insightful guy, and I came across this great blog post and article by Daniel Wasser and Gary Emmanuel, two fabulous and very well-known and well-respected attorneys in our business. And I thought it was something really important that we as a community should know about. You should know the opportunities that are here and also some of the possible pitfalls and things you should be wary of. So the presentation today is called The Practical Application of the New SEC Rules on Publicizing Theatrical Offerings, Crowdfunding, and the New Bad Actor Disqualification. And as Dan quipped about in his article, it has nothing to do with thespians, but about, well, I'll let Dan explain it. Let me just give you a little introduction. Daniel Wasser is an attorney at Franklin, WEINRIB, RUDELL, and VASSALLO. His particular focus is on theater law, representing producers as well as playwrights, underlying rights holders, and financiers. Broadway productions for which Dan has served as production counsel include Matilda, First Date, Evita, Alan Cummings' Macbeth, Godspell, Legally Blonde, Young Frankenstein, and The Producers. So he's had a little experience in the theater, but he makes up for it in other ways. And this is Gary Emmanuel, who is at, you have to help me because I don't know how to pronounce it. Sichenzia, Ross, Friedman, and Ference. Gary's a securities attorney representing both private and public companies that are navigating the process of capital raising. Gary and Dan were co-counsel for Godspell, Ken Davenport's show, which was the first successfully crowd-funded project under SEC Regulation A. Gary was formerly associated with Begelman, Feiner, and Feldman, where he specialized in securities in the securities aspects of theatrical offerings. So I'm going to turn it over to Dan and to Gary, and then they're going to do a presentation, take notes, and then we'll open it up for a question and answer, and then we'll do some networking at the end if we have time. Dan Wasser.
Well, thank you, Bruce. Gary, glad to be here with you. We're going to talk about what we've called this practical application of the new SEC rules on publicizing theatrical offerings. But we're actually going to talk about some more things. In particular, we're going to talk about crowdfunding, because that's kind of the flavor of the month. We hear a lot about that. And one of the reasons that Gary and I are so delighted to be here is that while we can talk to you about what the rules say, and we can speculate about how they, what kind of impact this may have, we're really looking forward to feedback from you, because it's what theatrical producers are going to do with these rules, which will determine whether it's just another useless law, or whether this is really an innovative approach which is going to transform the way theatrical financing is raised. So there's a little overview of what we're going to cover. All right, so first off, let's just relax and drift back to a kinder and gentler time in our nation when Congress could actually pass bipartisan legislation. I give you the Jumpstart Our Business Startups Act, signed into law by President Obama on October 5th, 2012, and a brilliant job of marketing calling it the Jobs Act. At least in those days, nobody was going to vote against something called the Jobs Act. So
I thought it was Steve Jobs.
the Jobs Act actually covers, it amends and adds quite a number of laws. Not all of them are particularly relevant for theatrical producers. Theater, and as you know, the Jobs Act was, I'm sorry, theater is not mentioned at all in the Jobs Act, as you might imagine. But there are 3 elements of the Jobs Act that are particularly relevant for theatrical producers. The first would be the publicizing of private offerings, which Gary will speak about in some depth. The second is crowdfunding, which I'll cover. And the third element of the Jobs Act that is of some importance for theatrical producers is a form of simplified public offering, which now would allow producers to raise up to $50 million in a private offering not dissimilar to the Regulation A type of offering that Godspell was done under. Now, as you will hear throughout, the only element of the Jobs Act that I've just mentioned that's relevant for theater producers, which actually has been implemented through SEC regulation, is the publicizing of private offerings. One of the other things we're going to talk about is something, the bad actor rule, which arises under the Dodd-Frank Wall Street Reform and Consumer Protection Act. And of course, as you know, that was enacted in the wake of the Lehman Brothers, Bear Stearns mortgage crisis, and its purpose was obviously investor protection, but not specific to theater. I mean, Too Big to Fail was not designed for Spider-Man. But what the element of the Dodd-Frank Act that we're going to get to is the bad actor rule, which Bruce has already mentioned and which Gary will discuss. Okay, we've probably all heard a lot about crowdfunding. Clearly, it's a phenomenon that arises out of social media, generally a pooling of large numbers of like-minded people to support a cause or a project, usually with each one contributing small pieces, small amounts of money. What most are probably familiar with are Kickstarter and Indiegogo, which are donation-based crowdfunding. So the donation-based model, first we should be clear, this is not a deductible donation. So it really is an interesting phenomenon of people writing checks to support what they consider to be worthwhile projects. That's not completely altruistic because there usually is some sort of recompense. So even in the donation-based model, you might get early access to the recording that you're helping to support. You might get some swag, Spike Lee autographing the poster from his new movie. So there's something there, but clearly what you're not getting is any share, any participation in the profits of what you're supporting. In order to have a financial interest in a project that you're supporting, you're going to need to have a piece of equity. And as you know from theatrical production, whether it's in the form of a limited partnership or a limited liability company, what you're selling to people is a piece of the business, a business that's being run by other people. And that passive investment participation is known as a security. And securities are heavily regulated in this country. They're regulated obviously by the United States and the SEC, but that's not enough. They're also regulated by the 50 states, each one of which has different rules. So whenever you step into some sales of equity, we have to deal with lots of laws. So we're talking here about Regulation A crowdfunding for Godspell. Is that really crowdfunding? Well, we call it that because it was done to the maximum extent possible online. That's how people generally were contacted. It wasn't done by producers having lunch with every investor. It wasn't done by the brokers calling up their clients. Rather, there was a website, people entered the website, and that's kind of why we're calling it crowdfunding. We also are putting new Rule 506C, which is the publicizing of private offerings. That also has the potential to be described as crowdfunding because, as Gary will discuss, if you can publicize a private offering, you can certainly take advantage of all sorts of social media to attract investors and communicate with investors. But what the Jobs Act actually covers is an exemption that is neither Regulation A nor Rule 506C, but there's a specific provision that they call crowdfunding. And it is close to what, to me, close but not quite, was close to the philosophical underpinnings of equity-based crowdfunding. And what was that? The notion was, if nobody invests too much money, nobody can lose too much money. So the government ought to take a kind of laissez-faire attitude towards that sort of situation. Let everybody put up, $100, $1,000, no big deal. So let's see how the government felt about that. But first, a reminder. Crowdfunding under the Jobs Act may not yet be undertaken. So even if what we discuss next, if you think that that's a marvelous approach, you can't yet do it because there are no regulations. And until we have regulations, the crowdfunding element of the Jobs Act is not effective. Now, in a stroke of marvelous timing, it turns out that tomorrow the SEC will reveal the proposed rules for crowdfunding. That does not mean that tomorrow you can start crowdfunding. These are proposed rules. They will be commented on. They will then be finalized. They'll then be published in the Federal Register. So at a minimum, you can figure 6 months. Okay. So these rules that are here, these are actually Congress's rules. These were actually put into the Jobs Act. This is not detailed, which has been provided by the SEC. And the number one thing we see is that crowdfunding is limited to $1 million in any 12-month period. So clearly not financing any Broadway shows on crowdfunding. And a producer can only utilize the crowdfunding exemption for a maximum of $1 million within 12 months. Now, as far as investors are concerned, this is consistent with the philosophy I mentioned of nobody invests too much relative to their position. So if you've got an annual income or a net worth of less than $100,000, you can invest the greater of $2,000 or 5% of annual income or net worth. Above $100,000 of income or net worth, obviously you can invest more. Producers, are not going to be contacting investors under the Jobs Act equity funding scheme. Rather, the offerings have to be conducted through an intermediary, a registered broker-dealer. How many registered broker-dealers are going to be excited about raising that level of money? Or through a funding portal. You may ask, what is a funding portal? Well, what we know is that funding portals will need to be registered with the SEC. They'll also have to be registered with FINRA. And they are going to have a variety of duties, such as ensuring that investors get disclosure documents, ensuring that investors get risk documents, ensuring that even though they can't touch the money, they have to somehow ensure that the money is not utilized by the producer until the minimum funding level has been reached. And they can't give advice, and they cannot get any kind of success-based compensation. So all those offerings, all offerings under crowdfunding to be conducted through a financial intermediary. In addition to that, you're going to have filings with the SEC. There are going to have to be disclosure documents for investors. In fact, I think if we're raising more than $500,000, there have to be audited financial statements. And you might say, well, if I'm starting up a new production, what's the big deal about audited financial statements? It's basically zeros, right? One would have thought the same thing, but Gary and I had an experience with the SEC where they caused a producer to spend thousands of dollars to get an auditor to certify statements that basically had zeros on it. So it remains to be seen what attitude they take. Blue sky requirements, one of the good things here is that through the equity crowdfunding under the Jobs Act, you will not have to comply with each state's separate blue sky regulations. So even if the states don't like it, they have to accept it. So based on what I've been saying, you can see that there are perhaps some practical difficulties with equity crowdfunding, particularly as envisioned in the Jobs Act. You know, the limited size of the offering, the limitation on the amount investors can invest, the cost of disclosure. You know, in $1 million offering, you're going to have at least, under the new rules, you're going to have at least as much legal and accounting work that's going to need to be done as before. Plus, you're going to have heightened disclosure requirements. And then here's another thing to consider. Let's say it works really well. And you raise, let's say, $800,000. Do you want to have 500 investors, each of whom wants to give you notes? Time will tell, but we're waiting for the SEC rules, and we don't have to wait very long. That's going to be tomorrow. And at this point, Gary, I'm going to turn it over to you.
Yes. Okay, so I'm gonna cover 3 areas. I'm going to start off by discussing what we call new Rule 506C, which is the rule that allows you to engage in general solicitation and general advertising when conducting a private offering. Then I'm going to talk briefly about some proposed rules that the SEC came out with when it approved the new Rule 506C rules, and then I'll finish off with a discussion about the bad boy disqualifications, which is it's an issue that hasn't really been focused on all that much by practitioners, and I think it's going to cause some real significant problems as people start to really digest the implications. So let me just get a sense from the audience. I mean, when I say Rule 506, just by a raise of hands, do you generally understand what that means? Okay, so we'll start with some of the basics here. Okay, so when you're conducting a securities offering, and Dan explained, briefly what a security is, you have two ways that you can raise money. Either you raise money publicly by registering with the SEC. That's a very costly proposition, and it takes a lot of time. And it's really, something that public companies that are doing IPOs go through. The alternative is to find an exemption from registration. Now, the main exemption from registration that is relied upon in the United States is Rule 506. It's so important that there is about as much money raised under Rule 506 that there is raised in the public markets. And the main exemption that's relied upon for theatrical offerings is, of course, Rule 506. Now, since September 23rd, just last month, when the new Rule 506 rules became effective, we essentially now have two types of Rule 506 offerings. What we call Rule 506B and what we call Rule 506C. So I'm going to talk about what Rule 506B is, first of all, so you can understand then what Rule 506C is. So in a Rule 506B offering, first of all, you can raise an unlimited offering amount. That's one of the big attractions of Rule 506. And you can contrast that with the new crowdfunding exemption, where you have that $1 million limit. So that's certainly something that's applicable to all types of theatrical offerings, whether it's off Broadway or whether you're going all the way up to Broadway. In a Rule 506B offering, you can raise money from up to 35 non-accredited investors or an unlimited number of accredited investors. Now, just to explain what accredited investors mean, it's a technical term to describe investors that have a specific high net worth. In terms of individuals, which is the most common form of accredited investor that you encounter in the theatrical world, there are two categories. One is a test that's based on your income. So it's if someone earns at least $200,000 in the previous 2 years and has the same expectation of earning that money in the coming year, or you can combine the salary of their spouse and then the threshold increases to $300,000. So that's the income test. And then there's the net worth test where someone needs to have a net worth of at least $1 million, not including the value of their primary residence. Now, the concept of accredited investors is going to become very important when we talk about Rule 506C. In a Rule 506B offering, if you raise money from non-accredited investors, you have specific disclosure requirements that are quite burdensome. However, if you raise money just from accredited investors, there's no specific disclosure requirements other than general securities law requirements not to commit fraud. You're also required in a Rule 506B offering to make a Form D filing. This Form D is basically a notice filing that you make with the SEC within 15 days of first sale, and you also make this filing with the states in which the investors in your offering are resident, and then you also pay a filing fee to keep the states funded at the same time. And then there are also some resale restrictions involved in 506B. It's not so relevant to theatrical offerings where you usually just have a one-time type offering. And then bad boy disqualification requirements I'm going to turn to a little bit later on. But the real kind of fundamental aspect of a Rule 506B offering is that you can't engage in any kind of what we call general solicitation or advertising. Now, these are very kind of, technical terms. Advertising is a little bit more easier to understand. You can't engage, obviously, in any publicizing of an offering on the TV, radio, newspaper, internet, LinkedIn, Twitter, Facebook, you name it. You can't do any of that in a Rule 506B offering. And in addition, you can't engage in general solicitation. So what's general solicitation? Well, you can only go out to people with whom you have what we call a pre-existing relationship. And so basically a pre-existing relationship is where you know that person, you have an idea of that person's financial wherewithal, that they're going to have the ability to invest in your offering. That obviously limits the number of people that potentially can invest in a Rule 506B offering. And that's where Congress came in. They said, hold on a minute. We've got all these people out there. We were living in the internet age. We're living in the age of social media. We want, we want companies to be able to reach out beyond their circle of, family and friends, which is the reality of who you go to in a Rule 506B offering. And that's really what prompted the new rules, where they eliminated the ban on general solicitation and general advertising. So, turning to new Rule 506C. Like Rule 506B, we've got an unlimited offering amount. Very important. Secondly, you can only conduct the offering with accredited investors. Now, what this means is the only people that can invest in your offering are accredited investors. You can advertise freely to unaccredited investors, but the actual purchases in your offering have to be accredited. You also have a Form D filing for a Rule 506C offering, and under the new rules, the new Form D has a box where you have to indicate whether you're conducting the offering under Rule 506B or Rule 506C. And then you also have the resale restrictions and bad boy disqualification, which I'll turn to a little bit later on. The key here, though, is in your Rule 506C offering, you can engage in general solicitation and advertising. You can go out and you can publicize your offering now on the internet. You can utilize Facebook. You can utilize LinkedIn, and it's a very powerful. The potential for this is hugely significant. Now, there are a couple of really important conditions if you do go out and you take advantage of the general solicitation and advertising. First of all, the issuer or the company is required to take reasonable steps to ensure that the investors investing in their offering are accredited. And secondly, all the investors in the offering need to be accredited, or you have to have a reasonable belief that that's the case. So the question really now arises, how do we determine if an investor is accredited? Now, in the good old days, before the new rules came into play, the way that you would ensure that someone is accredited is you would give someone a subscription agreement. They would fill it out. The subscription agreement has boilerplate language in that basically says, I certify that I'm an accredited investor. Alternatively, you'd have a questionnaire that would ask questions. Do you fall into this category? For example, do you earn more than $200,000 each year? Have you earned that amount in the previous 2 years? Do you have the same expectation that you're going to earn this in the next year? You say yes to this, you're an accredited investor. This is what we call self-certification. The SEC said self-certification in an offering that's conducted under Rule 506C is not going to be sufficient. You're going to have to take extra steps. So what steps do we have to take? Well, there was a big debate when the rules were being formulated about whether the SEC should provide an exhaustive list of what you can do, or whether they should provide a non-exhaustive list. And what the SEC in the end adopted was they provided 3 non-exhaustive ways in which you can determine whether someone's accredited. So these aren't the only ways that you can make the determination, but these are certainly three of the ways that essentially are recommended by the SEC. The first one, actually the first two, as you'll see, are really quite impractical because they require information that's quite personal to the investors. If you're looking to verify that someone meets the income standard, in other words, they earn at least $200,000, you're going to have to look at someone's W-2s, you're going to have to look at their tax returns. If you're looking to qualify someone under the net income standard, you're going to have to look at credit reports, bank statements, brokerage statements. I can't imagine many investors out there that are going to be willing to share that kind of information with a company that they're intent on investing in. The third alternative, I think, is the most realistic one, is where you have a third party that verifies the accredited investor status. And the SEC listed a number of different professionals that are qualified to do that. That includes accountants, lawyers, registered broker-dealers. These are the people that are in touch with the investor. And I think that what we'll see in the course of these offerings is that companies will then be turning around to the investors and asking that their accountant or their lawyer independently certify that they are actually an accredited investor. There's one small exception to the self-certification rule, and that is, and I'm not sure how relevant that is to theatre, but I'll mention it. If you have a company that has pre-existing investors that are already accredited and you've gone through the process of certifying them, you don't have to go back to them and re-verify them if you do another offering. In theatre, you're usually creating a new production company each time with a new set of investors, so I don't think that this particular exception is going to be of very much use, but it's certainly something that's worth keeping in mind. I just want to give you an example here of a platform, a crowdfunding platform called CircleUp, where we have a real example of an offering that's being conducted today under Rule 506C. I took randomly a product called Smari, and as you can see, they're looking to raise $250,000. They claim they have a pre-money valuation of about $4 million. And if you click on the links, you can see information about their financials, about the management. You can contact the CEO and ask questions. And if you're really interested in investing, you just click the Invest Now button. And it takes you through to another web page where you certify yourself as an accredited investor. And I think someone will then get in contact with you to make further verification. Now, if this kind of web page were to have appeared pre-September 23rd, this would be a clear example of general solicitation and general advertising, and it clearly wouldn't be permitted. But today, post-September 23rd, this is a good example of how this new exemption can be taken advantage of. Incidentally, there were they had about 35 offerings that were ongoing. None of them were in the theatrical field, so lots of opportunity out there. Mm-hmm. Okay, I'm going to turn now to the proposed SEC rules. Now, what the SEC did on the one hand is they said, well, we're going to allow you to engage in general solicitation as Congress required them to do so. But these rules were very controversial because the big concern is that the fraudsters out there are going to take advantage of the rules that eliminate general solicitation, and this is going to cause big problems for those more vulnerable to all these fraudulent schemes out there. So what the SEC did is they said, okay, we're going to allow this, but we're also going to propose rules that are going to reform Rule 506 and take steps to mitigate the potential negative consequences of eliminating the ban on general solicitation. I'm not going to go through all of the proposed rules, but I'm just going to highlight 2 or 3 of them just to give you an indication of how absolutely draconian they are. As I mentioned beforehand, when you do a Rule 506 offering, you're required to file a Form D within 15 days of first sale. Now, many times the Form D doesn't get filed for a whole variety of reasons. You're still able to rely upon your Rule 506 exemption. What the SEC is doing now is they're increasing the Form D filing requirements in a number of ways. One is they want you to file an advance Form D 15 days prior to your commencement of general solicitation or advertising if you're conducting a Rule 506C offering. Now, if you think about this for a minute, you're going out there, you decide that you want to conduct an offering. Who knows when you're going to start your marketing? It's not always you have a firm date. You may want to start an offering very quickly, but unless you get your advanced Form D out there quickly, you're not going to be able to commence your offering. That's one example. Another example of the problem here is generally when the SEC says that it wants something to be filed with it, the states say they want a filing also. So now, how is it going to work if you have to make a filing with the SEC on an advanced basis and you have to make filings on an advanced basis with the states? How do you know where your future investors are going to be? You have absolutely no idea. The SEC also wants what they call a closing amendment filing for your Form D. So not only will you have to file your Form D 15 days after first sale, but when your offering terminates, they want you to file a Form D. Now, if you just think about this logically, especially, and this would really impact the theatrical community, offerings tend to terminate when the show opens. The last thing you want to be dealing with is a Form D filing that determines that provides information about the end of the offering and how much you raise. It's not that the information is necessarily sensitive. It's the fact that you just don't have the time to deal with these kinds of administrative burdens with everything going on. Now, why is this significant? Because one of the proposed rules is to impose a very, very significant penalty on companies that fail to file Form Ds within the previous 5 years, which is, if you do, then you're not going to be able to rely upon the Rule 506 exemption for 1 year after you actually remedy your failure to file Form D. So just think about that for a minute. If you fail to make an administrative Form D filing with the SEC, you will lose your ability to rely upon Rule 506 for at least one whole year. And that would extend not only to the company, but to affiliates and predecessors. So the potential expanse of this rule is such that if you're a producer and you're producing a number of different projects, if you fail to file Form D for one particular project, that could impact another project that you're raising money for, and you may be prevented from utilizing Rule 506. Well, I have news for you. If you're prevented from raising money under Rule 506, that's the end of your career as a theatrical producer, because you're not going to be able to raise money. And for startup companies, it's the end of startup companies because they're not going to be able to raise money.
I also see legal malpractice claims coming out of this.
100%. Anyway, the comment period for these rules ends November 4th. If you feel strongly about this, it's not too late. You can go onto the SEC website and you can share your views with the SEC because they're getting hundreds of letters, most of which are very much against these proposed rules, and they're also questioning the constitutionality of this, because, you know, Congress decided it wanted to, you know, they called it the Jobs Act for a reason. They wanted to, you know, loosen up the rules, make it easier for people to raise money. And here you have a potential reforming of the Rule 506 rules that will make it much more difficult going forward to raise money. It's not what you think. Okay, bad actor disqualification. But bad actor disqualification is a new rule, a new requirement for complying with Rule 506. Doesn't matter whether you're doing a Rule 506B offering or Rule 506C offering. You have to comply with these rules. What's bad actor disqualification? Well, if you have a bad actor involved in your offering, then you will be precluded from relying upon Rule 506. Now, there's two elements to consider here. One is the category of what we call covered persons. If these covered persons are subject to what we call disqualifying events, then you can't rely on Rule 506. The second element to consider here are what are the disqualifying events. So I'll start off first of all with who are the covered persons. It includes the company, its executive officers and directors. In the case of theatrical productions, that usually means managing members and general partners. Investors in your offering, they're going to own more than 20% what we call the voting security. So if you have an investor that purchases a very large share of the production, they are potentially going to be what we call a covered person. And the most problematic element of this is a covered person includes anyone that's paid or will be paid compensation for soliciting investors. Now, in the theatrical world, we have to think of people like associate producers and co-producers that are very much involved in the money-raising process, and they would be covered persons. Now, what are the disqualifying events? Basically, the SEC has listed about 9 specific disqualifying events. So if someone has been convicted of a felony within the past 10 years that relates to some form of securities violation, that's a disqualifying event. If someone was formerly a member of FINRA and they've lost their license because of some securities related violation, that's a disqualifying event. Now, because the category of covered persons is fairly broad, it expands beyond management, the chances of having someone that's involved in your offering that is subject to a disqualifying event, particularly amongst the potentially the associate producer, co-producer world, is a risk that's significantly heightened. And it's certainly something, it's a question that you need to be asking now when you're speaking with potential co-producers. Is there anything in your background that could potentially cause us a problem and prevent us from relying upon Rule 506? Now, the SEC was kind enough to provide us with what we call a grandfather rule. So in order that the rule wouldn't have adverse retroactive effect, if someone has a disqualifying event in their history that occurred prior to September 23rd of this year, then you're not going to be prevented from relying upon Rule 506. Instead, you're going to be required to make disclosure of the disqualifying event to the investors in the offering documents. You just have to make a disclosure about it. And quite frankly, if you do have someone that that has that kind of issue, you probably would want to disclose it anyway, because it would raise fraud issues. and issues related to, you know, providing complete information and avoiding, you know, material misstatements and omissions. With that, I think we'll, you know, turn this over to Q&A.
Fantastic. Great, thank you, Gary. Fantastic. All right, so great. This was a great presentation. Thank you, Dan. Thank you, Gary. It's very detailed, but I think very clear. So let's turn it over to Q&A. We're going to do that for about, we probably have about 20 minutes or so. So, is that Bruce back there? Stand up so we can hear. By the way, I just want to say something that we're recording, videoing the presentation, so that if you speak up, you ask a question, your voice is going to be on the video, so you're waiving your rights here. The other thing is, before I forget, I wanted to thank Catherine Russell for providing the space for us. Thank you, Catherine. I don't know if you're here, but thank you. And also Ryan Pointer, who's our new marketing manager at Samuel French, for doing all the setup and videotaping. Thank you, Ryan. Okay, questions. Bruce.
Going back to the bad actor clause, as far as I know, co-producers and associate producers do not get a share of the credit from managing members, nor are they paid. They are simply on the production, learning to be co-producers and get credit on that production below title. But this bad actor clause that you just brought up makes me nervous because they're not being paid. So what is the distinction, and why should we even worry about it if none of these people are getting paid, and you don't bring anybody onto your production to solicit monies if you're, as the lead producer or co-producer, raising your own money?
Let me approach this very gently. From the point of view of the SEC, it is more likely than not, in fact it is almost certain, that from the point of view of the SEC, a co-producer who is getting a participation in the general partner's share of net profits is getting compensation. Limited. Even though that co-producer, it's not like a broker who's getting a fee for every sale. You're not reducing the amount of the proceeds that the offering gets. So the thinking from theater lawyers is nobody's being harmed. But the thinking at the SEC is, and we live in fear that someone's going to put this question to the SEC directly, the concern there is that from their point of view, sharing in profits, even though it's a contingent participation, is compensation, thus putting co-producers into that bad actor category. And when do they fit into the promoter category anyway? Potentially. Yeah.
I mean, you know, there's, you know, the issue of whether, you know, whether there's a relationship between the company and associate producer or co-producer has always been a problem for securities lawyers and theatrical lawyers in this field, because it's always raised the question about whether you need to register as a broker-dealer, because there's a so-called finder's exemption, but the reality is, over the years, the finder's exemption is extremely limited, and usually the people that are operating or purport to operate as finders are crossing the red line in terms of the activities that they're doing, and they do generally more resemble the activities of broker-dealers.
Well, you gentlemen realize that if this actually happens, and we're all precluded and have to schedule that document that you just spoke about, we all use co-producers and associates to raise money for us, sharing managing member percentages as a show returns, will destroy everything that we do, and none of us are going to want to have or share that schedule with those documentation.
Right. Well, that's why
It's
we.
very complicated. It's already complicated.
It's a significant issue, which is one of the reasons why we made sure that we would raise this with you. But again, what's worth keeping in mind is that there needs to be a disqualifying event. It's not that you just fall into the category of a covered person. There needs to be a disqualifying event. The problem is that many finders out there, or people that are operating as finders, co-producers, whatever you want to call them, many of them have checkered histories.
Not in the theatrical field,
Not in theatrical.
but in other areas.
But in other areas, it's a very real problem.
I
So
just want to finish this by asking this one question in regards to what we're talking about. Do you believe that before the Jobs Act thing was actually voted on, that they actually even asked people in the theatrical community how this would affect us? And do you believe that because Rebecca was so in the press that many legislators and many people within the SEC decided now it's time to us to clamp down on theater producers?
no,
Okay.
theatre's
There was one story that was quite out there and everyone read it.
yeah, no, I appreciate theatre was the last thing on their minds.
City Court was
How about back there? Yes. Oh, hi.
Just wondering if the 506B as in boy will still remain in effect, and producers can choose to use 506B as opposed to 506C and continue to operate as they have in the past.
That's a really great question. Thank you for bringing that up. Did everyone hear the question?
Why don't you repeat it?
Okay, so the question is, can you use 506B today, or can you just use 506C, or can you use both of them? As it stands today, you have a choice. You can use 506B and not engage in any general solicitation, or you can go down the general solicitation route. However, keep in mind that if you go down the general solicitation route, you've committed yourself to not engaging in any general solicitation. You've committed yourself to engage in general solicitation, rather. So you can't shift to Rule 506B. But you can potentially, I guess, shift from Rule 506B to Rule 506C, as long as there are no unaccredited investors involved, and that you take the steps to make the verification to ensure that all of the investors are indeed accredited. But you have that choice today in terms of how you wish to proceed.
So you could check both boxes in Form D?
No, you can't. You would have to make, but you would have to make that decision. But you can always change. You could change. You could shift from B to C, but you can't go from C to B.
Got it. Thank you. Yes, sir.
Yeah, two things. Number one is I was having a conversation with somebody else who thought even though there's a limit on the amount that you can raise right now with the solicitation, which could increase, that if you set it up as a separate offering for, let's say, $5 million in like a company that invests the $5 million in the whole thing, that still may be possible, or you could stop that offering and then do an offering for the other $10 million to get your $15 million musical. Do you guys have an opinion on that?
Correct me if I'm making certain assumptions, but I think the question that you're getting to is, can a co-producer raise money utilizing 506C,
Right.
using general solicitation and advertising to raise a piece of the offering,
Yes.
and then contribute that for an investment interest in the offering,
Correct.
in this, let's say, $15 million musical?
Right. A way
I think that's a great question, and let's consider the following. Let's say it's Scott Rudin is doing a $15 million offering, and he's doing it the old-fashioned way, 506B.
Mhm.
No general advertising, no solicitation. Yes.
Because then you're still
think so.
stuck with only raising money for plays. I mean, because you can maybe do a play for $5 million.
No. I think we just need to be clear here in terms of like the offering amounts. If you're doing a Rule 506 offering, regardless of whether it's
Right,
B or
that's true,
C,
it's unlimited.
there's an unlimited.
It's unlimited either way.
The issue of the issue of the offering amounts comes into play when you start talking about the new crowdfunding exemption, which is 1 million,
Right.
or Reg A, which is 5 million,
That's
or
right.
the new Super Reg A that will come out at some
Right.
point,
It was the
which is
5
50 million.
Right, it was the 5 million Reg A that was the discussion that
Right,
was
right,
happening
right.
with that particular.
But in that hypothetical of the 506B offering, I'm suggesting that I don't think that
You don't think you
506B
can separate
offering,
out the two pieces in that way? And then
not if the piece is raised through 506C methods. On the other hand, if somebody has formed a bona fide theatrical investment fund and has raised money utilizing general advertising and solicitation for unspecified theatrical investments, I don't think that would pollute the 506B offering.
Yeah,
So you
I
could
tend
do
to
that
agree.
for like a general fund and then take the general fund and put it into different productions.
Right.
Okay.
What you were just talking about was like a blind pool?
Right.
Mhm.
So let's say you raise $20 million to invest in a range of currently unknown theatrical investments. You can raise your pool utilizing general advertising and solicitation, and you can invest that money in a production that's utilizing 506B, the old rules, no general advertising and solicitation.
And 1 second, and if that blind pool names particular shows, or one, it's Andrew Lloyd Webber, and it's my next show, and it's called XYZ, and 5 other shows?
You know, we're in uncharted territory here.
So that's where I was really.
That's the lawyer's answer.
This question is 600 an hour.
Right, and then the other thing too is you've mentioned fraud under the disqualifications, but that one seems bigger. There's 9. Is there some that are under fraud, but we'd be really concerned?
They're related. The categories are very much related. They're different types of violations of the Securities Act that have a relationship with fraud, not necessarily, but that's the general theme when you go through them. It's extremely technical.
Terrific, great. Right here, thank you.
If you go from B to C, what do you literally have to do? You don't have to do a whole new offering? You just file Form D, or what's the process?
It's a good question.
What I can tell you is that we're in a brief period right now where if you had commenced an offering prior to September 23rd, then you only had one choice, which is 506B. Now, after September 23rd, you can actually have a hybrid offering. You can flip over into 506C, and the fact that whatever you've done in the 506B won't disqualify
So those
the
investments are
506.
But I think the fundamental question is, are you structuring the offering for accredited investors only? And I generally hope that most people do, because you generally don't want unaccredited investors in your offering for a variety of reasons, including the fact that you have heightened disclosure requirements, and also unaccredited investors tend to be more problematic in the long term, and they just don't have. Usually, they don't have the financial sophistication for investing in high risk offerings, in particular in theatres. So, to the extent that it's been structured already as an accredited investor only offering, shifting from one to the other shouldn't be too much of a problem.
Okay, right in the middle. You? Can't see you.
Thank you. At the risk of once again bringing up uncharted territory, I'd like to go back to the subject of the funding portals. to know whether there's going to be a new specialized funding portal evolved to deal with this particular regulation, and whether we can look forward to a theatrically oriented funding portal being there for producers to use, and what their reporting requirements might be that would take the onus off producers. Or I mean, not their requirements, but their reporting duties might be that would take the onus off the theatrical producers at this critical time that you talked about.
Okay. So we're going to get to your question, but the need for, remember, the funding portals relate to the crowdfunding element of the Jobs Act. Limitation $1 million. Okay. So the need for funding portals and the likelihood that they're going to be developing is going to be dependent on whether theatrical producers are actually going to take advantage of the crowdfunding rules, the crowdfunding that's permitted by the Jobs Act, which leads to the more basic question of how many productions are you going to be able to finance for $1 million or less, and can you do it cost efficiently? All the issues that we raised about how valuable these crowdfunding rules will actually be in practice. When it comes to the funding portals, I mean, if there is going to be substantial usage by theatrical producers.
Well, I mean, I think that you have to differentiate between the obligations of the producers and the obligations of the funding portal. The funding portal has its own set of obligations that Dan talked about. For example, making sure that the offering proceeds are not released before the money is raised, that they provide specific disclosures to the investors, and then the flip side, the producers have their own specific obligations to put together the offering documents and to make sure that they're going to comply and that they have, they need be audited financials, etc., etc. So I don't think there's a huge amount of things that the funding portal can do to defray the major obligations that a producer has. Now, there may be things going forward, like there may be investor management tools that a funding portal can provide going forward, which there may be some use for that. But the fact that you have a funding portal is not going to mitigate the need of a producer to meet its specific requirements under the crowdfunding exemption, and those requirements are fairly significant, which is why our view of it is that we don't think that the crowdfunding exemption is going to have a whole lot of use, unless there's people out here that think otherwise.
Well, there inevitably will be funding portals. I think in the independent film industry there'll be a lot of interest. And there'll be general interest. I don't think we're going to see early theater-centric funding portals.
Great. Yes, sir.
Yes, how, if at all, or is there any change to the definition of accredited investor as it applies to non-U.S. citizens?
Yeah.
Any change? Let me just repeat that question for the benefit of people at the back. Is there any change to the definition of accredited investors as it relates to non-US investors? In terms of the accredited investor definition, it doesn't make a differentiation between US or non-US. So if you are structuring an offering under Rule 506 and you're saying all of the investors need to be accredited, then they have to, each and every investor has to meet that standard, whether they're a US citizen or not. Now, there are different ways of structuring an offering under what's called, and we may be getting a little bit off track on the technicalities here, but something called Regulation S, which is a structure of an offering where you do it offshore, and it's intended for basically offshore investors, non-US citizens. But generally speaking, for the theatrical world, you don't do Reg S,
Right.
combined Reg D, Reg S offerings. But that's one way of maybe bypassing some of the accredited investor rules for non-US persons.
Great. Yes.
You mentioned that something about using the same investors for the same show. If we all have a lot of the same people that invest in our shows, do they have to be recertified since the burden is on us? The corollary question is, what's the penalty, and does that increase your income as certifying companies? But can we use the same investors who keep coming back on different limited partnerships for different productions without having to recertify them?
Okay,
And is there an expiration for their certification? And
that's a great question. The question is do you have to recertify existing investors within your investor pools? Now, I think that the first question is, are you conducting an offering at the moment where you have these pre-existing investors, or did you conduct an offering quite recently and you want to raise more money using those same investors? If the answer is yes to both of them, then you don't have to go through the process of verifying that they're accredited if they already self-certified beforehand and your intent is to conduct a Rule 506C offering. However, if your intent is to create a new production company and to bring in investors, I think you fit neatly into the SEC's grandfathering rules, and that the best course would be to try and fit within one of the three categories that I mentioned. Certify them under the income test, the net worth test, or have third-party verification. Now, as I mentioned, the list that the SEC provided was non-exhaustive. And the SEC indicated in its final rules that if you know the investors, then the extent of what you need to do in order to ensure that they are accredited is going to be much less than someone that you solicited randomly through the internet. But I think that, to keep in mind here, when we're talking about Rule 506, Rule 506 is considered a safe harbor. And what that means is that if you fulfill the conditions of Rule 506, you have a good Rule 506 offering. So I think that what the aim really here is to do is to make sure that you've done everything in your power to ensure that you've complied with Rule 506. So as a practicality in that circumstance, if you can't get the confidential information about income, etc., from the investor, it's just simply have a third party make that verification.
The other corollary question is, we didn't really cover it, but it's always seemed ambiguous to me, so I hope you don't mind me asking. The limitation on the number of front money investors, has that changed? What is it today?
4.
Is it 4? Is it 5? And
it's another wonderful question. So, is there any change to the number of front money investors? The answer to this is simple. There is no limitation on front money investors if you're conducting an offering under Rule 506. And the reason for that is because Rule 506 preempts state law. When I say preempt state law, I mean that the concept of having the 4 limitation of front money investors comes from the New York theatrical syndication laws. Those New York theatrical syndication laws are completely inapplicable if you conduct an offering under Rule 506. So if you do a front money agreement and you structure it for accredited investors only, and you structure it in a way that it's going to be compliant with Rule 506, there is no limitation on the number of front money investors. Now,
Even if you're not starting the 506 offering immediately.
No, but you can conduct multiple 506 offerings subject to what we call the rules of integration, where where potentially you merge. You would consider 2 or 3 different offerings being the same offering, and if there are problems with one offering, it contain the other offering. But you can potentially structure an offering with front money investors under Rule 506, and then do a few months later another offering under Rule 506.
I think the question is, if you have unlimited front money investors, then you could potentially raise it all as front money. And then where?
But then it's not front money.
Okay, so you raise the last bit and you call it. You know what I mean? But you wait till you have it. I'm sorry. The question I had was, so if federal law preempts the New York blue sky law, doesn't it preempt all the blue sky laws? And so then, is there any blue sky filings?
So there's a question about, I think in New York they have some accounting requirements, which I don't know if you're more familiar with that than I am, but I know they have some accounting requirements. I don't think they would be preempted, but what would be preempted are requirements to register and qualify with the state. In addition, what's not preempted are New York's powers to go after you for committing fraud. That's certainly something that's not preempted. And
so this is all in the context of Rule 506 offerings, not other types of
Correct.
offerings. The only ones that are preempting are
So
the
if you do it the
506.
old-fashioned way, the way we've been doing it with 4 front money people and don't use the 5016 plan, we do it the way we've always done it, and we don't do this crowdfunding and this new things that are offered to us, we're fine. We just continue doing business the way we do it, and not use this new thing that's supposed to help us that may not actually be helping us.
well, I mean, you can, when you talk about the old way, raising money from front money investors, there's a good chance that it's been structured as a good 506 offering. It's just it would be a 506B offering today, rather than a 506 offering.
You're saying that those are not subject to state blue sky filings?
They are not. It's the National Securities Markets Improvements Act, what, 19...
Why?
19, no. Just to be clear, you're required under Rule 506 to make filings with the states, but it's not a condition to your exemption. Therefore, your failure to file, which when you structure, if you were to do a front money investment with 1 or 2 investors, 3, 4, however many, under Rule 506, your failure to file with the SEC in the state is not fatal to your ability to rely upon Rule 506 and to claim federal preemption. The states may take a different view, but the reality is that unless there's fraud going on, or unless you have an unregistered broker-dealer doing funny things, the likelihood of the states coming after you and arguing that you failed to file Form D is very much reduced. The problems generally arise when there are complaints being made against you for potentially committing fraud.
So if you raised more than 4 front money investors, you went to 10, you went to 15, you went to 20, you still run the risk that the New York Attorney General might want to enforce the blue sky law and say, sorry, you can't do that because it says it in the Syndication Act. Correct?
If you've structured this as a Rule 506 offering, then they don't have a standing. The only standing that they would have is if there was fraud, of course. And there's something called Form 99. Form 99 is New York's equivalent of Form D. New York has, out of every single state, the wackiest blue sky laws. They're wacky, they really are. It's called the Martin Act. And they don't track the laws of any other state. In fact, there's no registration requirement under the Martin Act for securities offerings other than in instances of real estate, offerings just conducted in this state, and theatrical offerings. Those are the only situations where there's registration, unlike all the other states where there's a regime for registration of any securities offering. Now, New York has come up with this Form 99, which in some respects resembles Form D, but in other respects doesn't. It goes beyond the information requirements. And those of us that practice in the securities industry have argued to New York that New York doesn't have the right to require a Form 99 because of some Supreme Court rulings and the way that the Martin Act basically gets interpreted. And over the course of the years, New York has, I think, as a practical matter, accepted this argument and is not pushing for the filing of Form 99s. But I think that what we'll probably see over the next few years is that New York will adopt a Form D. It will abolish the Form 99, and it will in many respects start to bring itself in closer compatibility with the rest of the states as far as Rule 506 offering practice is concerned.
Terrific. I want to leave some room for people to network a little. There's a show here tonight in the theater, so let's just take one more question right here. Yes, sir.
Hi, I'm a registered broker-dealer. My company opening my capital intends to raise theater capital and some film capital worldwide. We thought about providing crowdfunding services as one of the services that our company provides. As a registered broker-dealer, may we charge a commission on the crowdfunding revenues or the capital that we receive?
Yeah, I believe that's the case. Yes, as a registered broker-dealer, you have that ability. But you're obviously, as a registered broker-dealer, you're subject to much, much higher standards in terms of your regulation. You're not only regulated by the SEC, but you're regulated by FINRA. So your ability to do that comes at a significant cost.
Great. All right, great. I want to thank our guests, Emmanuel. Great and informative presentation. We've recorded it. I'm not quite sure where we're going to post it yet, but look for it on LinkedIn, and we'll let you know. Thank you all for coming, and please, I believe there's a bar out in the lobby. Grab a drink and tip the bartender, and look forward to speaking with you all.